Hi, everyone. This is Sarah Butler with Faith Trust Institute, and I want to welcome you to today's webinar. Before we get started, I want to have a couple of comments to make. This webinar is addressing issues that arise specifically for institutions and organizations that are undertaking investigations into misconduct. We're hoping to have a follow-up webinar soon to address the complex issues of defamation for individuals such as survivors and whistleblowers. So this information about defamation law will be useful to both organizations and individuals. And I'm just going to say, since there are lawyers in the house, this is an educational presentation and it's not legal advice. So these are complicated issues, but we are hoping that this presentation will help eliminate some of the fear that can derail investigations and silent survivors. I'm going to introduce our presenters in just a moment, but first, technical information. So you should be able to hear me. If you're having problems with your sound, then check to make sure your speakers or headset are plugged in, the volume's turned up. Other technical problems are generally solved by logging off and then reconnecting via the link that was sent to you in your email. All of the audience members are muted, and but we do want to hear from you, and we know you're going to have questions. So you can submit your questions at any time using the question box that comes. We'll forward them to the presenters. And if you don't see the question box, there should be a little orange arrow on your screen, and you can click that and you'll get more options. The slides that you see are available as a handout, and you can get to those by clicking on the little blue box, and that will list all of the handouts, including a certificate of attendance that you can download if that's useful. And then lastly, we're recording this webinar to make it available for those who can't attend. We'd like to thank Morgan Lewis Bokius LLP for supporting this webinar, which leads us to our presenters. Emma Diamond Hall is an attorney at Lewis Bokius in Boston, and she advises clients on general litigation matters with an emphasis on intellectual property and media law, and she is the mastermind behind today's presentation. And Carol Murchison is a retired attorney who was a partner at Morgan Lewis Bokius office in Philadelphia, author, and works as an advocate with survivors of abuse by spiritual leaders. She offered pro bono support to Project Sunshine, which revealed abuse within the Shambhala Buddhist community, as well as many other investigations. So I'm going to hand it over to Emma, but please remember you can send your comments, your questions anytime. And here's the technical part of the process. Let's see if that works.
Mm-hmm.
You have that, Emma? Did that work?
1 second. I need to give permission for the screen recording. It's sorry, that's a different permission, so it would make me restart to accept permission to record the screen. Do you want to just control the slides?
How about I take back control?
Okay.
Let's see if I can find me. There we go. Show this window. Sorry for the. Okay. So let's try this. Everybody see that?
Mm-hmm. Okay, so just a roadmap to what we'll cover today. First, a little introduction. I am an attorney, I'm a litigator, but I also do media law, so First Amendment law. I work with media organizations on defending defamation claims and clearing stories in advance. So that would be sort of preventive defamation law. Carol, I'm going to turn it over to her in a second to give an overview. She's really the expert on the actual process of investigating these claims. That's something I have not had experience with. So after she explains a little bit about what she does, I'm going to go through just the basic legal framework for defamation claims, and we'll flag some that are likely to come up in this context. And then we're going to talk about some more concrete examples of the types of issues that you might face in an investigation, and going through some of the legal risks and the legal sort of opportunities or defenses that are available in each case. And then also I'd like to walk you through just the basics and logistics of what happens if you either get sued or just get threatened with a lawsuit. And then we may have time to talk about some tips of other considerations that you might think of ahead of time that could help you out down the road. So I'll turn it over to Carol to talk a little bit about the investigation process.
Okay, good. Thank you. So the investigation process is one that is really critical in thinking about defamation. And there are a lot of defamation questions and issues that come up. So I thought that it might be helpful to kind of just walk through where the investigation itself kind of fits in this whole life cycle, if you will, of some of these claims. So as Sarah said, I was a partner in the Morgan Lewis Philadelphia office, and I was an employment lawyer, and I did a lot of workplace investigations. And then since then, I have done, Sarah kindly called me an expert. I wouldn't say that, but I would say I've done 5 or 6 investigations of sexual abuse in spiritual communities. And of course, the issue of defamation is one that is ever present on people's minds. So if you look at the kind of life cycle of how this happens, we have one or more people who have allegations and they make them public to somebody. Usually it's to the organization itself. Sometimes it is. And an independent investigation is begun. Now, sometimes, and this is my experience in this, those allegations are ignored. Sometimes they are ignored because people don't realize that they need to do an investigation. Sometimes they're ignored because they don't believe the people who brought the allegations forward. And oftentimes what happens when a spiritual organization, or any organization for that matter, ignores those kinds of allegations, that they find a way to get somebody's attention. And often that is media, and sometimes it's lawyers, and sometimes it is somebody like me and other people who are working in this space, and they say, can you help us get through to the organization and show them that these allegations are credible? And so then what I often do is what I would think of as a preliminary investigation to show that an independent investigation needs to be done. Often then the investigation is begun, evidence is compiled, witnesses are interviewed, a conclusion is reached, and the standard there is more likely than not. So you'll see this in a bunch of different things that, where people are reporting on their investigations. They'll say it's more likely than not that this happened, because we don't always know 100%. And then the conclusion is communicated to the community. So at each and every one of those steps, there's an opportunity for a defamation claim in a lot of different directions. Survivors are afraid of coming forward because they're either explicitly or implicitly afraid of defamation, and then the organization in the process of doing the investigation is also concerned about what they can say during the investigation and how they communicate that to their community afterward. So I'm going to turn it back to Emma and say, now we're going to hear about what the lawyers have to tell us about investigations. And along the way, we'll don't worry if you don't understand every single part of it, because I guarantee you that we're going to get to a point where we're going to have one single sentence that's going to help you understand what you as an organization need to do to protect yourself and the organization from defamation claims.
So,
Okay.
To prove a defamation claim, the burden is on the plaintiff to show that someone has made a false and defamatory statement concerning them. There's been an unprivileged publication to a third party. We'll talk about each of these in a little more detail. There's some sort of fault by the publisher, the speaker, that amounts to at least negligence, and that fault standard varies. We'll talk about that more. And then either proof that the statement is defamatory per se, which means it's a certain category of document, of statement that the law has presumed is going to cause you harm, so that you don't, it's an exception to the normal rule that you need to prove, the specific damages of how you've been harmed. If you don't fall into one of those categories, then you need to prove special damages, which is to prove, exactly how the statement has harmed you. So first, falsity. The most important thing to remember with defamation is that truth is a defense. So there's a lot of complexities that we'll talk about in terms of what it takes to show that something is true, and get a defamation claim dismissed on that ground. But, if you are on the right side of the facts, in theory and almost always in practice, sometimes at a cost, you should not have any liability for defamation. The standard is substantial truth. So you can get details wrong. You can get the color of someone's shirt wrong. You can get sort of smaller details wrong. The question is the gist or the sting of the statement true? And so that's really going to look at what's the message that they're kind of challenging, what's the factual content that's being conveyed in that message. It has to be factual, so it has to be something that's capable of verification. It can't be a matter of opinion, and that's because it runs into First Amendment concerns, because opinions are basically ideas, and the concept is that if I show you the underlying factual bases of an opinion, you should be able to draw your own conclusions about it, even if I'm making very outlandish conclusions that really make no sense. If they're opinions, that's on me. So one thing to consider with the fact-opinion distinction is a plaintiff will often argue that your opinion implies a certain factual basis that you haven't disclosed. And so you're kind of leading people to think that you have some sort of factual basis for your opinion. So an example of this is if you just say Bob is an alcoholic, then that might imply that you've seen something that would lead you to believe that. And if you say Bob is an alcoholic, I saw him drink 2 beers at the Red Sox game, and that actually is true. That's what you saw. He drank 2 beers at the Red Sox game, and you make that opinion and conclusion that he's an alcoholic based on that. Even if no jury would agree with that opinion, it doesn't matter, because you disclosed a verifiable and true factual basis, and you're free to make your own conclusions from that and to speak about those. So that's something to consider, is that you are free to draw conclusions and make opinions publicly. You just need to consider what factual bases are being implied and what factual bases underlie your opinion, because a lot of statements are going to be somewhat mixed. And so you do want to be considerate of the factual underpinnings that you actually have in support of your conclusion or opinion. Another consideration is the context and type of speech. So going back to sort of the opinion fact distinction, if you're on like a shock jock radio show, or if you're in a political debate, often there's a lot more leeway to kind of do hyperbole, to maybe draw conclusions that really don't really match up to the facts, but are just matters of opinion. Those will often be protected as opinion. So you'd be surprised at some of the fact-seeming proclamations that have been held to be non-actionable just because of the context, including some things that President Trump has said. So it's almost like if you are so outlandish that people aren't really going to think that you are communicating a fact, even if that same statement made in a different context, maybe by someone else, would be actionable, it's not coming out of your mouth in that context. So those are the sorts of, very detailed and evolving facts that the courts have to look at in these cases. So the statement must be of and concerning the plaintiff. The plaintiff must be identifiable. If you kind of make vague statements about, where we have an interest in keeping our community safe from, abuses of power, there's those sorts of things, those usually won't be held to be referring to, someone who might have allegations around them. And, really you're supposed to be looking at the statement, yes, in context, but if you have to rely on, people would have all these other facts that I personally have, and they would know that this is really a veiled reference to me, that's less likely to fly. So that a lot of cases are lost on that prong as well. So an unprivileged publication to a third party. This is, I think, a slide that hopefully will put a lot of people at ease. There's a lot of statements, especially around this type of topic of investigations and misconduct, that are going to be protected for various, social purposes. The law kind of carves out these safe harbors. Some of them are more safe than others. So we have the absolute privileges. If investigatory privilege, if you are, speaking to officials in connection with an investigation, that's going to be privileged because, we want to encourage maximum transparency and candor in those investigations, as well as allow, I think, confidentiality in some cases that's tied to that interest. Statements made in the litigation, obviously anything you're doing in an actual litigation. And a side note on this isn't to say that you're shielded from any, consequences if you, lie in court about someone. Obviously that could be perjury. You could have different types of liability that could attach, but we're just talking about defamation. And so with litigation, this comes up often in this in the sort of Me Too context where, yes, you have a right to sort of issue a denial of, certain allegations. But if you start going beyond it, and you get into the territory of calling someone, calling the victim or the accuser a liar. Alan Dershowitz had some statements of, he kind of really went beyond and said, this is a serial prostitute, a serial perjurer, so perjury, that's a very specific, charge, and he's not referring necessarily to what she said in his case. So that's one where the court said, okay, we're going to let this proceed because this goes beyond, just this absolute privilege of something made in a litigation or just sort of a mere denial or commentary on the actual litigation. Qualified privileges, we have a common interest privilege. This is going to be really relevant here. So if the circumstances lead any one of several persons having a common interest in a particular subject matter, correctly or reasonably, so it has to be somewhat reasonably, to believe that someone else sharing that interest is entitled to know information. So this is one where it's been pretty well established that this would cover, members of a church or a faith community in connection with an investigation. There's been cases that would cover if there were allegations against a youth pastor and the disclosure to parents of the children in the youth group that was held to be subject to the common interest privilege. This is another one where we've seen, a more expansive interpretation recently, I think for the best. And so this can now come to include a survivor support system. That disclosure could be considered common interest. Disclosures to potentially other previous employers or potential former employers of someone who's been accused of misconduct. So, there's sort of a spectrum of where this is safer and where it kind of depends on the judge or the jury or the jurisdiction. But the good news is the trend is, I think, to be more expansive and to consider, especially for certain people, depending on what their position is, it really is a broad common interest to sort of bring attention to these sorts of allegations. The fair reporting privilege, this could come up if you had a criminal investigation or criminal charges filed. You have leeway to report on those sorts of official records. And what's interesting about that is it can be a protection even if that's not, the actual source. If you could point to the same information apparent in a public official record, you can rely on the fair reporting privilege. And again, it's the same substantial truth, gist or sting. So it doesn't have to be exact. There's some margin of error that's allowed for, but if you're reporting on something that the official records reflect that same sting or gist, you're pretty much in a green zone. So the fault standard for defamation depends on whether you're dealing with a public or a private figure. So for a private figure, there's a little more protection. A private figure is a negligence standard. So you may not have, you may have done some investigation. You may have some basis to believe something is true. But if it's not true and, the jury finds that a reasonable person, should have known, you could still be liable, subject to all the other factors we'll talk about. For a public figure, they need to show that you had actual malice, and that means that you actually had, truly in the traditional way, bad intent toward that person, or that you were basically reckless as to the truth, and that's a very hard standard to reach. The public figure analysis is often a central part of defamation cases because, it really is very hard to meet that other standard. And so that's often the end of the case. Practically, there are limited purpose public figures. So it doesn't necessarily have to be a household name. It could be someone who is well known within a certain industry or a certain community. It could be someone who's spoken out on a controversial issue. And the test applied sometimes for a limited purpose figure is, have they thrust themselves into the vortex of controversy? And that doesn't necessarily mean by the actions that you're talking about. It could mean that, they've held themselves out as a public official. A public official is always going to be, a public figure. It could depend more on just their role and the context in which they're being commented on can play in. So it is a very kind of fact-specific analysis of whether someone's a public or private figure. The good news is clergy have, in many cases, been held to be public figures, as well as other religious officials. So that there's pretty good law on that in terms of these types of cases. Is that what you're going to say, Carol?
Yeah, Emma, that was very interesting to me because I wondered whether a person, because a person who's a head of a spiritual community is, from my thinking about it at least, very well known, very public within that community, although they might not be for the community next door to them. And so is it common for the head of a spiritual organization to be held to be a limited purpose public figure?
I mean, I think in the context I've seen where the subject is, misconduct or abuse, I think the courts, especially recently, are more willing to make the jump, even if they are only well known, locally. They're more willing to say, look, this is a matter, of concern to this entire, community. So it is a sort of matter of public interest, so in a way, that person has thrust themselves into the vortex of, abuse in religious organizations by being a religious leader, and so it's a squishy kind of analysis, and, it's not the kind of thing you'd really want to make definite, predictions on, but I think more and more you'll see courts saying, yeah, that's fair.
And I just want to clarify what I think that you said, which is that this is really important, because the difference between proving that someone was negligent, which is like we made a mistake or we didn't do an investigation that was thorough enough or something like that, is proving malice is harder. Is that right?
Much harder. Yes, much harder.
Okay, good. Thank you.
Okay, so we talked about special damages and libel per se. There are categories of libel per se. Give it in my notes. So was there a slide with that listed, Sarah?
No, I think that it goes to an earlier one on libel per se, which is the moral turpitude slide.
Oh yeah, okay. It's yeah, okay. So false claim of moral turpitude, crime of moral turpitude. So yes, rape and sexual assault are crimes of moral turpitude. Fraud and any sort of dishonesty-based crimes are generally considered crimes of moral turpitude. This is another one where it's a very old-timey phrase, but it actually does. In general, these elements do evolve with the times. So to impute inchastity, that is still a live law, but the way that it's been applied is probably a little narrower than it was when it was invented. A loathsome disease means a communicable disease or a sexually transmitted disease. And then the last one that you see most commonly is that it relates to a person's business or profession, and it would damage them in the esteem of the people that they do business with or within their industry. And so in a misconduct case like this, you would probably see a couple of these come into play, but definitely crime of moral turpitude would be sort of implied, and then also they would say this is damaging because it implies that I'm a risk to people in my profession and that sort of thing.
So it means, Emma, that to us that then this person, since all of these things, as you suggested, are going to fall into that category, that any defamation that might arise out of these kinds of situations are defamation per se, and the complaining party does not have to prove that harm was done. So that makes it easier on that side of the equation.
Yeah, and it's paired with the question of, is it defamatory as well, because the question of, is it defamatory is really, is it likely to harm their reputation, and but you also don't have to prove like I lost this job because of it. Although if you wanted specific amounts of money, you could do that, but the jury is free to kind of infer damages. Okay. Okay. Yeah, so that's if you fall into those categories, which will probably be the case here. That's libel per se. So anti-SLAPP motions, these are another thing that I think should make you a little more optimistic. These are statutes that many states have that allow a defendant who's being sued. We're talking about defamation suits here, but it doesn't have to be a defamation suit. The idea is if you're sued and you think it's for some sort of public participation, speaking out about a matter of public concern, and you think that the suit is simply, a strike suit to basically just shut you down, to waste your resources and to intimidate you, which I think we do see in the context of misconduct. You can get it dismissed without going through the process of discovery, which is the most costly and often most invasive part. And that's often what really, when people are trying to intimidate you using a lawsuit or a threat of a lawsuit, discovery is the leverage that they have, because it's extremely expensive, extremely costly, it drags on for years. And it's it's invasive. Your text messages, your emails, you have to withstand a deposition. So what a slap motion to dismiss does is it says, hey, Your Honor, these are meritless accusations. This is just to shut down me speaking out on a matter of public concern, or otherwise, it could be freedom of association, other sorts of constitutionally rights that we would consider public participation. And this is just to shut me down. And then the burden goes to the plaintiff to show that there actually is merit, but they don't have the benefit of the full discovery process. So this can be really a positive thing in this case, where you're actually getting to air, if there's good evidence supporting the allegations, you do have the opportunity to sort of air those out in court. And often the defendant doesn't have enough to say that there's merit. So there's been a couple of suits by people accused of sexual assault or sexual harassment that have been dismissed on this grounds. And so that public matters of public concern analysis, you'll see it's kind of similar to the common interest analysis in a way. It's similar to the public figure analysis in a way. But more so, we've been seeing that speech about sexual assault and sexual harassment, even with private figures, that's dicier territory. If it's just someone who just is kind of someone that's definitely dicier. But especially if it's someone in a workplace, even if it's not a famous workplace, that's more and more considered, all right, this is really a matter of public concern. Say you feel like your employer isn't taking things seriously, and maybe you go public, and maybe, the way that they are handling that is a matter of public concern. So it's, again, going to be case by case, but it's just it's a good leverage for, I think, survivors and advocates of survivors and organizations.
Yes.
Investigations.
Yes.
So the Cy Temple case is one where the court held that, yes, the question of whether the founder of this temple was making women feel unsafe, even though he wasn't super famous, it satisfies the matter of public concern element. And I think that sort of more modern analysis is going to be something you see more often now. Okay, so one last sort of quiver in your, or arrow in your quiver as a faith community is the ecclesiastical abstention doctrine, and that is a doctrine in which the courts, sort of thinking about the church-state distinction is where this all ties back to. They decline to intervene in internal ecclesiastical disputes, and so oftentimes discipline of a pastor or a minister or a faith leader can fall into that. And so that's another sort of method you could use to try to get a defamation suit dismissed. And again, it's similar questions that you see in the other analysis. Okay.
Okay, shall I take this on, Emma?
Yes.
All right. So what I saw from what Emma has gone through with us is that the most common working statement that those of us who are working in this area, those of us who are in faith communities who may be tested in this area, is this statement. And I ran it by Emma to make sure that it kind of would pass legal muster. So I said, when we make a statement concerning another person, and that's usually the person who has been alleged to have committed some kind of sexual misconduct that could harm their reputation, which it absolutely would, the statement should be objectively true or not done with malicious intent and made after due diligence. So what does that mean when we're communicating these issues? And so to me, Emma, the objectively true is that at a certain point in the beginning of the investigation process, what we're saying is not Joe is a rapist, or Joe is has sexually assaulted women. What we're saying is there are allegations that this has happened. And that's a difference, isn't it? That's the difference in just the language of that, in what is at a high risk of defamation and what is at a lower risk of defamation. Is that true, what I'm saying?
Yes, and I mean, there is a responsibility to not simply repeat publicly allegations that haven't been vetted at all.
Right.
But we try to take it in steps and follow where we feel we have enough facts. And so when we say we've received allegations or we're conducting an investigation, we usually try to keep maybe that phase of disclosure a little more narrow. And then when we have a report or a conclusion that's usually filled with a lot of facts from someone like Carol, then we may be able to consider a broader audience and be able to say, our independent investigation concluded, X, and refer to that investigation. Now, that is an opinion of the investigator. The fact that they concluded that is true. The opinion does imply certain facts that are not maybe disclosed in your statement, but those are referred back to. And then it's sort of kicked back to the plaintiff to say each one of these factual underpinnings is false. And so that's basically a mini trial.
Right. And that's hard, isn't it? Because if you're doing an independent investigation, then you are consulting a lot of people, you're interviewing people, you're reviewing documents. So there's a whole lot of factual pieces that have to be denied in order for someone to be successful in that defamation claim.
Yes, and by actually disclosing the report, in a way, it's almost a strategic advantage of, hey, they're going to see what first of all, a strategic advantage of, in a motion, in a normal case, in a motion to dismiss, you can't attach, all this factual stuff. You have to wait to discovery, between anti-SLAPP, and if you sort of attach or reference this detailed factual investigation in your statement, then that becomes the statement itself, and you may be able to attach those right away and say, Your Honor, look at all the facts are there, and they haven't actually challenged each of these underlying facts, and you might be able to get it out that soon. So in a way, or you might stop them from suing to begin with, because they don't want to. I don't know if I had it in here, but at some point I was saying it's like the Streisand effect of, I don't know if everyone knows that story, but I think Barbara Streisand prohibited, photos of her house being published or taken, and it became like the most Googled, photo on the internet, because everyone says, oh, what is she trying to hide? So if you, sort of bring this lawsuit knowing this is going to be Exhibit A and it's going to come out, it's already out there, but more people are going to click on it when you filed this lawsuit. And by the way, when you filed this lawsuit, maybe this is on a faith community's website right now. When you file a lawsuit and that goes up on PACER, which is, the public filings of federal courts or whatever the state equivalent is, then all these other media organizations with bigger audiences are going to say, oh, fair reporting privilege. Now I have these pleadings I can rely on. And so that's going to lead more people to, these factual, underpinnings, which, we assume are not good for the accused if we've come to this conclusion. So
it's an interesting point for the communities that have to deal with that, in that the transparency, from what I understand, is something that can be, from a strategic point of view, not even after a lawsuit is filed, but keeping a lawsuit from being filed. Because it occurs to me, Emma, that from a practical perspective, somebody who's been accused of these things, there's been an investigation. The investigation has been thorough and neutral. And it's based on, and I want us to look at two different ones that have come out on reports that honestly, I would think that a lawyer would hesitate to take a claim of defamation like that because it can't be successful. Am I dreaming? Am I optimistic?
I mean, I will say, most of the defamation cases that I've seen representing media cases, we get them out on motions to dismiss because of fair reporting or because of otherwise there's public documents that we can attack right away. And so this is a place where, you're not actually a media organization, but you're going to be sort of stepping into the shoes of one without, having that privilege, because in most cases you're not going to have an investigation that has public official filings on it. And so you're kind of giving yourself that same advantage by making public this, private investigation that you've had done. And so they're going to know what your evidence is going to look like, and you're going to get that in front of the judge very early. And I think it can really help you out, assuming that it's, all phrased responsibly and vetted, and, privacy considerations are obviously something else. But
Sarah, do we have a slide for the two reports that we talked about, the LA Opera and the Spirit Rock, or shall we do them now? Emma, what do you think? Oh, there we go. So because I think this is going to exactly what we're talking about. These are, and Sarah has kindly put these in the handout so that you can click on them and get them. And you'll see that these are two statements that have clearly been done with the help of a lawyer. That's what I always think, right? That somebody like Emma has looked at these and has said, here is what you need to say in this public statement. But if you look at the LA Opera, which you may remember had Placido Domingo was accused of sexual misconduct. He was their music director. They conducted an investigation, and I thought it was very interesting. I highly recommend it to all of you to look at. And what you will recognize in there is when I say it starts with an awareness of the allegations. It doesn't say he's guilty. It doesn't say anything, very carefully, very narrow, as Emma said. There were allegations against him. Because he's our music director and because he's high up in the organization, we hired a firm to conduct an investigation. Then they talk about, what did we do in the investigation? Here's how we reached out to women who might have been affected. Here's how many people we interviewed. Here's how many documents we reviewed. What they're showing, Emma, from my perspective, knowing what I know now, is that they're showing that there's no fault. He's a public figure.
Yep. This is
right?
like a draft motion to dismiss. They're saying, first of all, they're saying we investigated given the seriousness of the claim. So they're saying, they're saying this is why we didn't immediately make any judgments. These claims are serious, which, by the way, is also then helping build your case for a matter of public concern. And then you go through and they say, here's who we talked to in the investigation. So then that's building the case for all of those disclosures being protected, and the investigation being thorough. And so, it's very hard to say this is a statement made with actual malice or reckless disregard when you have a law firm saying this is how thorough our investigation was. And I also like that they sorry, go ahead.
No, go ahead.
I was just going to say, I like that they, there's some feeling behind it. There's some, they say they thank all the women for sharing their stories and it's going to affect real change. And again, that's great legally in terms of, I'm putting that in my brief to say this is a matter of common interest, public concern and everything. But it also is, I think, goes to show that you can really be a good advocate and ally and not be scared, because actually that's, in some cases opinion anyway. So that's sometimes the ones that you might be the most scared of because they're, matters of opinion, or you think they're polarizing or political. Often that's actually the safest statements to make.
The other thing that I thought was interesting in their statement was they never said that he did it. They never said, he touched these women inappropriately. What they said is that the statements were credible. The allegations were credible. And they talked about why. Because all of these unrelated women showed the same pattern of misconduct. And then they said they did not find Placido's denials credible because he had a lack of awareness. I think that was probably because, many people have a lack of awareness of the power dynamic that is involved. And they did then go on to say what they didn't find. They didn't find that he retaliated against people. They didn't find that it was a quid pro quo where he had to do that, where the women had to, he said to them, sleep with me or you're fired, basically.
Mm-hmm.
And so I thought that was a terrific example. The Spirit Rock one is there also. It's a little longer, but I encourage all of you to look at those and to see what, I don't know, I kind of think of, Emma, this is a good defense here.
Yes, yeah. A couple things I really love about the detail that they go into in describing their sort of judgments on credibility is one thing that's always bothered me is, when these cases are disparaged as, oh, it's a he said, she said. Well, actually, or her, all it is her word. Okay, well, actually, according to the law, her word, if credible, is evidence. And so.
Yes.
And so what I love about this too is it's pulling back and it's looking at all the systemic factors that used to be used to undermine credibility of victims and witnesses to, do the opposite and say, this is actually very common. This is consistent. The level of discomfort varied and some people didn't want to talk because of trauma or their memory, just talking about how these things, this is actually very common to see, and they talk about they didn't report because of his importance and stature, and we now know that's I think very quickly are coming to just accept those things more broadly, but I think making them explicit is very helpful, from a advocacy perspective, and also just legally you're making your case very tight.
Yes, absolutely. Thank you for chiming in on that. You had an insight into it that's very helpful to me.
Thank you. Okay. Okay, so I think we kind of covered this already, but like I said, the audience is kind of going to vary as you go along. I do think there's broader protection now in the beginning stages than there used to be, in terms of we might consider a broader audience that may be sort of at risk or may have information relevant to the investigation, including talking to prior communities. So it doesn't necessarily need to be internal strictly during the investigation, but a little more limited so that you can be comfortable that you're in the common interest bubble. And then after, I think the next slide. After is what we just talked about, right? So, there's going to be some support. Again, the bubble is kind of getting bigger as the courts start to take these things more seriously. But there's a bunch of arguments you could make that could really give you a lot of protection for a public statement. I'm just going to talk a little bit about them, but I want to make clear that these are kind of just emerging in some cases. So, don't feel like these are safe harbors yet. But there is some law to say that you have a right to speak publicly about misconduct for an employee or by an employee, or I assume an employer or any other sort of work related. I assume church related would count as well. Misconduct under the employment references exception. So, we don't know who else this person might kind of come to work for or interact with. And so there are some cases where they say even statements on the internet which isn't just someone calling you up and saying, should we hire this person? There can be protection for that. And again, that's the sort of thing that might also fall under the anti-SLAPP public participation stuff. And so, yeah, we talked about what you want to do. Disclose, even if you incorporate by reference the factual premises, as long as you're confident that they're credible. And then, like we talked about, including the context of why you're making certain credibility determinations, including the fact that, someone's memory might not, the fact that someone may not remember details didn't necessarily lead me to, refute their credibility, because I know this is common. And that sort of contextual factor, I think, really helps show that you were not negligent or reckless or having actual malice, and show that, that's probably true, actually. That's it for that. Okay, so what if we get threatened with a lawsuit? So hopefully you're feeling a little less panicky about these things after learning some of the tools that you would have access to. But remember that threatening a lawsuit is not the same as filing a lawsuit, and filing a lawsuit is not the same as winning a lawsuit. So, someone might, hire a lawyer to write a letter and have no intention of, paying that lawyer to file a lawsuit. So, I would try to get in touch with counsel, and the sort of factors you would think about is, how likely is it that this person will actually sue? Could they afford it? Could they afford it reputationally? Is there stuff that's going to come out that's just really not going to be worth it? Would they have any way to prove it's false? And what costs would they have to bear in terms of, facts coming out and attorney's fees in the process of even trying to prove that? Then a lot of this is going to be a public record, so it might be a broader audience than it already is. And things like, what are the resources available? What's the personality? Are they someone that's likely to be litigious, or, does it seem like that's the last thing, they would think of? Probably if they're sending a letter already, then, it's not out of the realm. But there's a lot of factors to think about in, would they sue? And then, of course, it goes to, the merits of what would a case be like, because they should be hopefully asking those same questions before they're threatening. Yep.
Emma, I just heard you say something very interesting, which is that person has to prove that they are false. Is that right?
Mm-hmm.
The person who is suing you for defamation has to prove that they are false. If
the statement is, that X did bad behavior, then they would have to prove, that that's false. And defamatory.
It's really difficult, isn't it? I mean, I think that's one of the other tools that people should be aware of. And I myself, as a person who was threatened with a defamation suit, it felt, like I wanted to faint, actually, was the thing that came to mind. But when you think about it, having to prove that it's false means when there is some element of truth in the whole thing, that they don't want that to come out.
Yeah, truth is a defense. So, and then, depending on statute of limitations and things like that, there could be some real criminal liability concerns, and you're going to put yourself under a deposition. You're going to have all these other witnesses investigated. You're going to have your emails discovered. You're going to have your text messages searched. What else could be uncovered?
Yes, that's right. What else could be there? Yeah,
and a lot of times they're banking on that never even coming up, because they're banking on, you get a letter from a lawyer and that's it. You're scared and you can't afford to even hire a lawyer to write a letter back. And so end of story, you just take the blog down or whatever.
Yeah.
So if you actually get sued, definitely seek counsel ASAP. Usually you do have to respond in 30 days, but that's all very, routine. Although you might be filing a motion to dismiss, but usually you have more time to actually get your case together and file anything substantive. But there are deadlines that come very quickly, and you can really risk a lot if you don't get right on it. You want to talk to your attorney about issuing litigation hold to make sure that any documents are preserved. Presumably, if you've already done an investigation, those are already in place. You may want to connect with counsel if the victim is or the survivor is represented, just to have those two attorneys link up because they may be also named or potentially named. And then I just listed some pro bono options. This is kind of a burgeoning field, but I do know that a lot of big law firms have taken on some of this work before. And then I also know there's firms that specialize in representing Me Too witnesses in these sort of matters, defending and countersuing. So there's the Time's Up Legal Defense Fund. There's some First Amendment organizations that I would consider might be an option. So that's a good thing to look into. Victim Rights Law Center is based in Boston, but I believe they're a national organization. And then, yeah, big law firms. If there's, especially if there's a defamation or media law practice, those would be good people to reach out to about potentially representing you pro bono.
Emma, I'm conscious of our time and our audience. Sarah, do you want to give us some questions? Because I know that Emma and I are happy to stay, and if people need to leave, they certainly can, but remember that it will be recorded, so the questions should be up there on the recording.
Yeah, so there's one question. There are times when we protect the identity of the complainant if there is concern about safety. Using investigation report would be to use it as a defense against defamation would reveal information that could jeopardize a complainant. And how would you work around that?
It's an interesting question. So Emma, from the investigation point of view, almost every single one that I have done, the complaining parties have been anonymous in whatever report that I give. I speak to them, I know them, but their names are not made public. So what happens then?
Well, if the LA Opera statement actually does note that they did, guarantee anonymity, and they explain why. It's another case where it's interesting because you're not a media organization, so it's not like a confidential source. I mean, one thing to be aware of is you could be ordered to release the name to the other person, but presumably he's going to find out anyways because he should be asked about. At some point that's going to happen. So that is just one thing to consider, that you don't probably have like the journalist shield law that might protect a confidential source. So you should be aware that there may be an order to name the person, but that's probably already going to be something that's available to the accused at some point anyways.
So Sarah, I think if I understand the question correctly, that it is possible that if something went into litigation, that then that name would have to be revealed. However, in an investigation, for example, the investigations that Faith Trust does, where they are hired by the organization, they are communicating, they are interviewing the person who's been accused, and they are giving them the names because they have to, because that person has to be able to defend him or herself. So in that case, they know if they've been interviewed, then they know.
Well, actually, that's actually not necessarily true in terms of the investigation that Faith Trust does, because there are many complainants who will come forward, and the stipulation is that their names have to remain confidential. And so we will give the accused the complaints, but not necessarily the person who brought the complaint, because this is not a legal action that we're doing. And so our primary concern is protecting the confidentiality of the complainants, if that's what they need to feel safe to go through with the process, because otherwise they don't necessarily feel willing to go through this process, because it's potentially damaging, harmful to them. So
yeah, I mean, I would say I don't think that you as an organization are under any obligation to include someone's name or identifying details in a statement like that about the investigation. I think that there's a possibility that through either action against maybe they name them as Jane Does, but the person would have a couple different legal avenues to try to get the identity, but it wouldn't be, on you to reveal that.
So basically, they would have to go through a legal process to force
Mhm.
the release of the names if it got to that point.
Right.
Right.
Yes.
Yeah.
Emma, I have a question, which is for survivors. So, is there, of all of this that we've talked about, if I'm a survivor, if I'm a person who has been sexually assaulted by a spiritual leader, and I come forward, are there any protections for me to keep me from getting to the suit and the motion to dismiss, other than what we've already talked about, the kind of practical things? So do I have a common interest? Do I have a matter of public concern? What protects, if anything, what protects me as a survivor when I say this person sexually assaulted me?
Yeah, I think when you're reporting it to the organization, that would be protected. That should be protected as common interest and investigatory.
Okay.
I would think. I mean, again, they could prove actual malice, so they could say you just invented this, because you have a vendetta against me, and that would, that if you have that, then everything else kind of falls into place. But we're assuming that you would almost never have that.
That's my experience, is that there's
Yeah.
I've not encountered that. So I don't think that women come forward. This is, just my experience, but women on these claims don't come forward on this because they, are interested in getting back at people, because there are easier ways of doing it than.
Right, exactly, right.
Right?
So that's kind of my understanding, is that actual malice is not too much of a concern
Yeah.
in that instance.
Excellent.
Okay. Oh yeah. So the last thing was just that some of the things that you're probably already doing or hopefully thinking about doing in terms of your policies and your investigation process are going to help with litigation as well. And we kind of already covered that in terms of if you have a very detailed record and you've really done a thorough investigation, all of those are going to come into the discovery process as well. And that's going to be the same sort of evidence that will help you in litigating a defamation claim or prevent it from ever having to go to litigation, hopefully.
So I
Yeah,
don't know if we want to. I don't know if we
I
want to
don't
go
want to
through the
keep
rest of the.
people. Yeah.
Okay.
Um,
So I will say that the presentation has a list of resources that people can look at if they're interested in exploring this a little bit more. Faith Trust has a bunch of resources also available. Responding to Clergy Misconduct is a handbook that takes people through the process of an investigation. And so I think that's actually a really great resource for people to think about. And lastly, I want to thank you both for being here and for this presentation, and to Morgan Lewis for allowing us to do this. And again, we really would like to do a follow-up that looks at defamation for individuals, as you were talking about, Carol, like as a survivor or a whistleblower, how can I make sure that, I can tell my story and my truth and not be fearful. So any last words before we close up here?
My thanks to Emma for enlightening us on so many points of the law here, and to say that, this is the thing that stands between these things coming out, for women actually having an opportunity to have their voices heard, and for organizations that hear the stories to feel like they can go forward without fear and do the right things without being sued. So extremely helpful. And thank you, Emma.
Thank you. Yes. And one of the things we talked about when we first started talking about doing this is the history of the law, sort of, the lack of, investigation and transparency, has ended up, being a huge liability for faith communities. And I think that the protections that we actually have in defamation law, which are much stronger than in most every other country, are actually a real tool that you can use in being an ally and helping to, your own liability on other factors, I think, is helped by doing a thorough investigation like this. And I don't think that defamation law should be holding you back, as long as you're aware of these sorts of hurdles.
Yeah.
Excellent. Thank you so much.
Thank you, Sarah.
Thank you.
We'll talk to you soon. Bye.